I know you don't want to be injured all your life, but don't settle that case too.
All right, welcome to another episode of the Justice Team Podcast. I'm your host, Brandon Simon. That was Grayson Goody with Sell Out, one of my favorites. We're running out of songs, so we've been recycling them if you've been watching our podcasts. This episode, we're talking about pre-litigation. We've had an excellent panel, but before we do that, we'll talk about drinks. Mr. Bartender, what do we got?
All right, today we've got a...
Introduce yourself.
I usually wait to get introduced.
Okay.
Come on,
Sorry.
Brandon.
This is Marat Abehan. Tell us, what do you have for us?
Today we have the good old espresso martini. I knew it was a favorite from a few shows ago, so I thought I'd bring it back. And what says pre-litigation? Like an espresso martini, right?
I don't get the connection.
Yeah,
Can you
Just think about it.
Okay.
Now you get it?
I got it.
All right,
good. Okay. All right, so we're talking pre-litigation today. We'll do some introductions. We'll start to my far left. Deon, why don't you say hello, introduce yourself?
Hey, Brandon. My name is Deon Goldschmidt, and I hail all the way from South Africa. Came here specifically for this podcast from San Diego. So I'm happy to be here. Thanks for having me, and I look forward to chatting with you.
That was very professional from Deon. If you know Deon, that didn't sound like Deon. I think he's a little...
You know?
A little loosey-goosey today. Brett, say hello.
I'm Brett Sachs. I hail all the way from down the street in Irvine, California. So it was a long 5-minute drive, but we made it.
What's the name of your law firm?
Sachs Law.
And to my right, we've got a commuter. She came from Las Vegas.
Yeah, big commuter, Southwest Airlines. April Bonifatto. I hailed all the way from the desert in Las Vegas. Law firm is Law Office of April and Bonifatto.
And is that where you were born, April?
I was.
Okay.
Don't judge me.
I won't.
Okay.
Deon's in no position to judge.
Oh, thank goodness.
We'll get
And
into
then
that later.
to my far right, one of my favorite people in the world, Benjamin Swanson. Say hello, Ben.
Hi, I'm Ben Swanson, and I have offices in Southern California and Northern California.
And the name of your firm is?
The Swanson Law Group.
SLG.
That's right.
Yeah. All right, so we're talking pre-litigation today. Everyone here does some pre-litigation. Some of them do exclusively pre-litigation. So, Brett, let me ask you, what is pre-litigation? What are we talking about?
Well, I think pre-litigation to us is the workup of a case, helping our clients obtain the medical care that they need. And basically make sure that they work within what they have to build a perfect case while getting them, the type of relief that they need. And it's basically anything before you file a lawsuit. So we do work exclusively in that area.
Deon, care to elaborate?
I think that's pretty much the same. I think communicating with the client is an important issue, and the success of any pre-lit practice is dependent upon making sure that a client gets the treatment they need, that you're liaising with the insurance companies, and most importantly, probably communicating with the clients.
So, big umbrella, anything before litigation, pre-lit, right?
Yep.
So, Ben, you do trials, you do litigation, you do a lot of pre-lit.
Yep.
So, and I can open this up to everybody, but why focus, some firms focus mostly on pre-lit? Why choose pre-lit as opposed to litigation? April, Ben?
Well, I think pre-lit has a very good utility to it. A lot of cases settle before lawsuits filed. And it's also a good opportunity as plaintiffs to get to know our clients before they get examined by the defense and called liars and all those great things. So it's really one of the, I think, strengths to a plaintiff's case is to have that time.
I agree with all of that. I also think it's a good time, if you are going to go into litigation, to let the other side know what type of diligence you're employing, how you're handling your case, if you're communicating with their client, how well you know the case. And then maybe at the 11th hour, they'll settle, pay policy limits or above that.
So, a lot of firms choose to do pre-lit as opposed to litigation. Are there some advantages or disadvantages? Let's just start with advantages. Are there some advantages to keeping a case in pre-litigation as opposed to litigation, and what are those?
I would say absolutely. I mean, every case is different, but there are trends and that they kind of line into. And if you have a commercial policy or a policy that you want to open, it's better to do that in the pre-litigation phase when you're dealing.
You just pushed a hot button for me. I hear open policies, I get all hot and bothered. Let's talk about opening policies pre-litigation. Ben, you and I mediated a case yesterday,
Yep.
right? That was small policy limit, and it was an open policy case. How important is it, Deon, to not just settle for policy limits if there's a chance to open? First of all, explain opening policies and how important it is to really be diligent in trying to open policies and why.
Well, I mean, obviously, opening the policy if there's a severe injury speaks for itself. If you've got a policy, for example, of $100,000 and a person is having a spinal fusion, you're going to do your best to open the policy so that you can get the compensation that the claimant deserves in regard to his injuries. Opening the policy very briefly, if somebody's involved in an injury and the third party has $100,000 policy limits, if the third party tenders those policy limits under a policy limits demand, that's going to be the end of the story. I mean, obviously you could sue the tortfeasor, but in all likelihood they don't have assets and that type of thing. So you're going to take your $100,000 and you're going to move on, leaving, of course, the third party, if he does not have underinsured motorist, with the $100,000. If you can get the policy open and the insurance company is stupid enough to do that, which
Are insurance
invariably
companies stupid?
which invariably happens, we obviously want to open the policy, and in that event, we generally like to hand it over to the Simon Law Group and let them get
Thank
the
you.
millions.
Your gift card is in the mail. Appreciate it. $25 to iTunes. Yeah, April, can explain to us? You do same with Ben. You do all spectrum of everything, not just personal injury, but you also do in personal injury. You do pre-litigation, you do litigation, you do trials, but you do a lot of pre-litigation. Let's tell us maybe why it's easier to open a policy pre-lit. What's your advantage of trying to do it at the pre-litigation phase?
I think the advantage to doing it at the pre-litigation phase is you have enough time to give the insurance company a ton of opportunities. So you can write a demand letter, get updated medical records, write another demand letter, give them another opportunity, and then they never want to pay it. And so you can say over a period, depending on certain states' statute of limitations, say I gave you 4 chances, 5 chances. So you have this whole range of time to give them the opportunity and then use it against them if you have to file it in litigation.
All right, Ben or Brett, jump in on that.
I think the advantages of doing it in a pre-litigation setting strives around the lawsuit itself. And, the biggest bad faith, statutes out there are basically putting their insured at risk for excess, exposure. So if we have a $100,000 policy, we have a client who is run over and having multiple surgeries, and their economic damages would outweigh the policy limits. The fact that objectively is worth more than the defense's policy puts their insured at risk. They have that fiduciary duty to their insured, the defendant, to protect them and act on their behalf so that they don't get sued. Since we haven't filed that lawsuit yet, that risk is always there. And I think that fear, depending on who you are and how well you do it, helps us, open policies up in the pre-litigation setting and allow them to kind of, in so many ways, hang themselves sometimes.
So, Ben, I'll pose to you sort of a hypothetical. You got a client that comes in, like Deon said, $100,000 policy. Client is clearly surgical. You could probably you do your demand and they don't pay it. You think it's open, but they'll probably pay that $100,000. What advice would you give to an attorney that maybe isn't as seasoned about pursuing an open policy case as opposed to we'll settle the $100,000, we'll get some client. He doesn't have the surgery yet.
Right.
What is your obligation on a pre-lit phase for your client to make sure that you're doing the right thing?
Well, I think, as Deon alluded to, communication is key. And by that point in time, hopefully I've had enough client contact where there's some trust. And you just have a frank discussion with them and say, we can go on an open policy, but it's going to take time. And there's a lot of hoops that need to be gone through. So, if they're okay with it, I'm okay with it.
Sure. So, I think a lot of attorneys probably just want to do everything and anything they can to get that policy limit. But that's, sometimes it's not in the best interest of the client, though, right, April?
I agree with that, especially if they've had to wait over a long period of time and treat, and then they're like, oh, yeah, we'll just give you the policy. It's like, well, you lost the opportunity.
Yeah, so I think, we do a lot of litigation, and a lot of people bring us their cases when you need to file a lawsuit. And, my advice to people that do a lot of pre-lit is always do what's in the best interest of the client, right?
Absolutely.
And it's not most of the time, it's not in the best interest of the client, especially if you think that policy is open.
100%.
Just to set off with the policy limits. But like Ben said, you have to have that discussion and tell them, hey, this will take more time and more effort, but it's more important that you get your compensation fully. It might take some time, but
yeah. And the other thing is you know me very well, and I hope they don't pay.
Ben, why do you get up in the morning?
To open policies.
Yeah, any attorney out there that has a license plate, vanity plate that says policy limits, say nah. And Ben has one open policy. Yeah.
But Brad, I think that's or Brandon, I think that's important to note that, especially if you're going to primarily do, pre-litigation work, that you do put your client's interest at heart and put it before your economic bottom line, because as we all know, we all work on contingency fees. We all have bills to pay, and we all have, you have to get through our lives. But at the same time, you have somebody else's life in your hands. And when you know that their claim is worth more than the policy, you have to do everything in your power to get them what they deserve and not to settle for less just to move it through the line. And I think maybe that's what you were alluding to a little bit, was to get it to someone who can either open it up themselves or you do it, and don't just settle because you can.
Right. And just one more little point on that. Reputation is everything. And these insurance companies know who they're dealing with. And if they don't, they learn pretty quick. So, it's good to take a stand and mean what you say. Integrity is everything in this business, as it is in all of them.
Absolutely.
And I guess in many instances it's important, even if it's not a policy limits case, and you get an offer from Allstate for $8,000 and the case is worth $23,000, there's a tendency to think, you know what, I can't take this to trial because there's no money in it for me. But you're not doing your client a service by doing that. And in essence, you're not doing yourself a service, because if the Allstates of the world work out that you're not a guy who's going to take a principled stand every now and again and take a case to trial, even if it's a loser for yourself, they get to know who you are, and they get to know what to do in instances when you send a demand. So even if it's not a policy limits case, sometimes you just got to suck it up and run a 2-day trial just to tell Allstate or Nationwide, hey, we're not going to take your shit.
Why you got to pick on Allstate, man? You got a bone to pick.
Geico.
State Farm now. How about that?
Well, all of them, right?
There's one that's the worst, but yeah.
We won't mention it.
No.
So I mean, another advantage, and it's not as common for us because we do a lot of litigation. But if you're settling cases pre-lit, there's not a lot of costs, right, April? I mean, usually you're not paying for depositions. So you're able to usually maximize the client's recovery in pre-lit as opposed to litigation, right?
That's true, because you're only really paying for medical records for the most part.
Yeah. And then your fee is lower for the most part. I mean, at least most contingency fees, it's a third, and then 40% into litigation. So if you see, I tell attorneys or prospective clients, if they're coming to me and I say, if the attorney that you might be signing up with wants to file a lawsuit right away, That's probably not someone you want to go with. You know, let them do their thing pre-lit and keep the costs low and maximize recovery.
Well,
It's
Brandon, in
less
some,
stress.
we do a
Client.
fair amount of vape cases and
Vape?
explosion cases.
Products
and in those
liability,
kind of
yeah.
cases, you have to file straight away. So
Yeah.
there's some instances where you have no choice. We've got some trip and falls where there's severe injuries, and you're never going to get an adjuster to pay big money on a trip and fall without filing. So in the main, I agree with you, but there are some instances where you have no choice but to file immediately to get somebody's attention.
And one just more point to add to that is the insurance industry knows those attorneys that wait until the statute
Yeah.
runs to file, and then those that do it proactively. So that's just one more thing to keep in mind.
So they're indexing everything we're doing. So you have to be very conscious when you're working your cases up and know that they are tracking that and they put that in their system. And you want to be known as someone who knows what they're doing.
Yep.
So what about talk about some of the advantages of pre-lit? What are some disadvantages pre-lit? Brett, anything pop into your head?
No, I love pre-lit.
You don't do a lot of do you do any litigation at your firm?
Very little.
Okay.
Deon mentioned those cases where it's not a policy limits case. We're getting maybe like a $15,000 offer, and we think it's worth $35,000. We'll file on it and go through the discovery phase and some little stuff like that. We're not, but we're going to farm it out if it's something that needs to go to the distance, experts, and trial. But we are about 98% pre-lit. Yeah.
Okay. Ben, can you think of any disadvantages of pre-lit?
It's hard to know what the policy is sometimes. That's probably the only issue.
Yeah. How many times do you ask for the policy limits and they tell you?
Very rarely. Very
And
rarely.
they don't have any. There's no
They hide
verification
it.
that it's accurate, right?
Right.
April, any disadvantages to being just pre-lit, not really litigation?
One of the disadvantages for me is the delay. So I don't like to wait the entire or even get close to the statute. I like to be like 12 to 18 months-ish. And then I think at that point, the position the insurance company is taking. So why not, come on into court and say everything you've been telling me for the last 12 to 18 months, or the judge, really.
Murad, you've been involved in a pre-litigation battle yourself personally. Is there any advantages or disadvantages to pre-litigation?
Well,
Or was that a confidential settlement? I'm sorry.
how about this? From a CFO,
A guy I
standpoint-
know.
From a CFO standpoint, I could say,
Oh yeah, you run the costs. Yeah.
Yeah, I could completely agree that pre-litigation costs versus litigation costs are night and day.
Yeah.
So
You could probably resolve most pre-litigation cases without spending more than $1,000, right, Brett?
Easy.
Yeah.
You can't resolve any litigation case without it's $400 or $500 to file and serve a lawsuit. So yeah, it's expensive.
Well, Brandon, let me put something out there. Ben mentioned something. What does one do, Ben? Maybe you can tell us in your practice if you don't get the policy limits. Let's say you've got
a good question.
a case where a guy is involved in a car accident. There's 20 grand's damage. Whether he needs surgery or not is debatable. He may not, but certainly he needs epidural injections. He needs these kind of things. And you've got, let's say, a USAA policy with a third party. You've got a 1530 UIM. How do you deal with that kind of case? And maybe you can
Very
tell
specific hypothetical.
Yeah, really.
right. And I know what you're getting at. The not high dollar cases. Maybe they're worth 150 or 250.
And what was the policy limit?
And you don't know the
policy.
You don't know the policy. That's the point.
Oh, okay.
Problem.
So you don't know the policy,
Okay.
but are you telling your client without knowing the policy how much to treat, whether to treat through a lien, whether to treat through health insurance, through Medi-Cal? How do you deal with that kind of issue? And one advantage that I do in those cases, I file straight away just to get policy limits.
Right.
But I'd be interested to hear what other attorneys do in those instances.
I'll send them letters that say that, you failed to disclose the policy limits and Dr. X is recommending this. I'll assume that the policy is over $250,000 if you don't respond in 7 days. things like that. But if they don't, then you file. Yeah, because that's the only way that you're going to get it.
So
And how often do you get a response?
Pretty often.
Okay.
So
Ben's letters are phrased in such a way that he always gets a response.
Yeah, one
It's
way or
very-
another.
That's a good question, though. We deal with that a couple of times. Sometimes USA is hard to get. They protect their stuff. We have letters that we send out. I think a very important aspect of understanding personal injury in California, at least, is that the insurance companies do have a duty to communicate with their insureds. And with our rep letters, we always ask in writing to disclose the policy limits, and they always respond back with the same generic sentence that we don't have permission, we've asked, and we'll let you know whenever they give that permission. So if we are in a situation like that, we will send a follow-up letter very clearly explaining that this is now our second time in writing asking, and non-disclosure might be in the best economic interest of your company, but it's not of your insured. And please, go ahead and communicate that with our letter and sign off on it. And if you don't sign off on it, then I'll assume you didn't give it to them. And, then we're going to have to file and get it in discovery. And we get about 75% good feedback with that.
Yeah, another thing that I'll do is a policy limits demand sometimes, with the client's okay. And then, that tends to ferret it out as well.
We research the policies in Nevada.
We do too.
We do too, but some are not easy to get.
Yeah, USA is hard.
Yeah.
But we also communicate with the adjuster themselves. We explain to them, this is what our client's going through. This is what they're being recommended for. A lot of times attorneys want to hide all this information in pre-lit from an adjuster, but that adjuster is the one that's going to fight for you at the end. So getting a relationship with them and communicating with them will allow them to, one, set proper reserves when you do demand, but also they'll be the ones to push their insured to get consent. So we talk to them as well. I think that's pretty important.
Brett, I have a question. So what happens when you run into the instance where, let's say the policy limit's $100,000, and it's a case that's probably worth $100,000, but they're just not going to pay it pre-lit. They're offering you 80, 85, but you think if you file a lawsuit or somebody else files a lawsuit, you'll get 100, but the fee goes up, right?
Of course.
Or if you don't want to file a lawsuit, you have to give it to somebody else. What do you do in that situation?
If I sincerely believe that the claim itself is worth substantially more, and $20,000 is a lot of money to a lot of people, and it's just a lot of money in general, then we'll do what's right. And we will file if we have to. We will farm it out. If it's a situation where I believe that once we file, before they have to respond, because we serve right away, because we don't want to wait, then I'll tell them the fees aren't going to go up. If we get within a month of filing, I'm not going to raise the fees on you.
You hear that, everyone? Brett Sachs lowers his fee.
We do not negotiate, even though we have to by law.
No, I mean, if you're not doing that as an attorney, you are a scumbag.
Absolutely.
Yeah.
Don't settle for It's so bad when you see, because it all goes back to the end. They have data on thousands and thousands of attorneys, and they're going to look up, okay, clients in Beverly Hills, they have 1 injection or 2 injections, they have $70,000 in meds, there's a $100,000 policy. The average settlement is $40,000. That's how they value these claims. They don't actually look at it and value it properly, and that's one of the biggest problems. So don't be that attorney that settles for less, because it's easier. Get it to somebody.
Right. All right. I have one more little topic before I get into the feud. The family. They run the Family Feud in South Africa, right, Deon?
No.
They don't have game shows in South Africa?
No, we don't even have TV. We listen to the radio.
So, for us that do a lot of litigation, we get our clients through other attorneys most of the time. How do you, April, Ben, how do you guys get your clients in pre-litigation? They're coming to you off the street, so how are you guys getting your clients? And how do
We
you
steal them from Ben.
How do you build a client base?
You want to start?
Sure. A lot of my client base comes from friends, family, colleagues, other pre-lit lawyers in town. Las Vegas is a small community, so, cases come that way. And from California, actually, because I went to law school down here, so a lot of California people will send me Nevada cases.
Yeah, for me, it's been 10 years of working hard up in Northern California, and the word kind of gets around. My favorite group of people to represent are Hispanics for a lot of reasons. You know, they get bullied, and I don't like bullies, and they're humble and all
You don't
those
like
people.
bullies, says the guy who was bullying me for eating lunch today.
Well, I'm a bully to bullies. But, so that word of mouth, and then I have 2 marketing companies that help spread the word as well, and the various periodicals or magazines, things like that.
Brett, Deon?
Brett, go for it.
We do some advertising. Obviously, since we specialize in pre-lit and we need a decent amount of client base, and we like to help the everyday person, we do advertising. But we also go around and we get a lot of good referrals from litigation firms who, because of the way that their business is set up, can't take on the lower type of cases with lower property damage or policy limits, and we're happy to take those cases on to help those clients get the justice that they need, and we would split our fees with them.
Deon?
So, in my experience, the best...
Cappers. Use cappers. I knew it.
Off the record. In my
They
experience, the
stole my truck.
I sing for my dinner. People hear me sing and they generally come to me. Referrals are generally your best clients in my view. So even if we take on small claims sometimes, I don't refuse a small claim because in my experience, that client who you do a good job for is a referral source for many, many other people. So when people say, why do you take a claim for 15 grand? Well, some of my best claims have come from referrals from those specific people. So if you treat people right, you'll get referrals, and your best clients are your referrals because they come from a trust source.
That's how we built. I mean, we didn't start out as a litigation firm. It was me and Bob, and we didn't do any advertising. We just took every case off the street we could get, and it was a 15 policy, and then we'd waive our fee, we'd do whatever we could, and it's return business. I mean, that's how we got our first big case. The motorcycle accident, a wrongful death case. It was a family friend of a client, and that's how they came to us. So treat people the right way, and in the long run, it works out.
A very wise person once said that if you give enough people what they want, you'll get everything you want.
Who was that wise person?
Zig Ziglar.
Dirk Zig. What? Zirk Ziegler.
Zig.
He wrote a
Ziegler.
book called, I read that book like 20
I heard
years
Dirk
ago.
Dirk
Good book.
Diggler from Boogie Nights. That's what I heard.
Well, there's that too.
All right.
And Brandon, what we say is, when a client signs a retainer agreement on a small case for a third, I always say to them, you're signing for a third, but trust me, if we don't do well, I'm not going to charge you a third because, and I tell them this.
You hear that? Deon negotiates his fees as well. There we go.
I say to them, you know what? My most important thing, and I mean it, is when you leave and go out the door there, I want you to be happy because every happy client that leaves brings in 2 others. Every unhappy client chases away 10 other potential clients.
I like that.
So it's a business.
I can see the Instagram story now with Deon Goldschmidt. There it is. That was the quote.
Right.
That's going in.
I mean,
you
that's
go.
really all
There you
that
go.
needed to be said.
Correct.
All right, so we're going to break it up a little bit. We're going to play the feud. Timmy, cue the feud music. He's going. I caught him off guard. There we go. Murat,
Yes.
can you do the announcements, please? It's like Price is Right,
Yes.
They have the announcer. Come on down.
Oh, okay.
It's also like Family Feud.
Oh, welcome to the feud. And on the left side, we have Deon and Brett. And on the right side, we have April and Ben.
I chose this.
All right, so I want to know when you guys are signing up a case as pre-litigation attorneys, or as not even pre-lit attorneys, just attorney, a case comes to you off the street. What are the most important questions or most important things that you want to know besides, obviously, what are your injuries? No particular order. I have 6 answers on the board. We'll start with Ben and April. What are the top 6 things that you would ask a prospective client? What do you want to know before you say, okay, I'll take your case?
Whether there's a police report, liability.
Liability, yes.
Okay.
That's on there. You can pass or play. Can we get a ding? No ding? Ding. Ding. Okay.
Answered so quickly.
April?
Any pre-existing injuries.
Pre-existing injuries is on the board. Keep going.
Property damage.
No,
I told you.
That's how they play in South Africa.
We don't have TV in South Africa, and you haven't explained the rules to me, you know? Makes it difficult.
That's true.
property damage is on the board.
Does that mean I get points?
Yeah, we'll
or-
just keep going. Brett, now you're up. Yeah, you get points. You win. 500 points for Deon.
Everyone gets $1 billion.
Yay!
So let's backtrack. We got property damage, liability, pre-existing condition.
Yeah.
He's filibustering.
Insurance.
Yeah.
Thank you.
I grouped it all into
Yeah.
one. Health insurance, auto insurance, Prop 213.
Yep.
You know, do you have UIM? How often do your clients have UIM?
I have full coverage.
That's what they say. Yeah. That's the thing. Nobody,
not the same.
nobody knows what UIM is, but it's not expensive. Brett, tell the people what UIM is. If we have any non-legal listeners, I guess.
It's UIM and UM are underinsured and underinsured or uninsured motorist part of the policy. So if you are in an accident involving an automobile and that person who caused the accident is either uninsured or your claim is worth more than their policy, so they're underinsured, you can be protected by your own insurance company's policy.
And it might not work like this in Nevada, but in California, so it's a net, right? So if you have a $30,000 UIM and the third-party policy limits are $100, you can't tap into the UIM. So it works better in Nevada too.
Stackable in Nevada.
Yeah.
Case value is higher.
Yep.
That's one of
You
the
hear that,
reasons.
Dion?
Buy a house tomorrow.
We're opening up an
Stackable.
office in
Come
Nevada.
on out. We are very
And
inviting.
it should be. I mean, it should be, right? And
Yes,
it's-
it
should be.
When you
Absolutely.
hear that it's not, it's when I
A
first
lot of
time I-
jurisdictions don't do it the way California does.
Yeah, the most
Because why
consumer-friendly
pay
state in the
UIM?
union is not very consumer-friendly.
Yeah.
when it turns
Why?
to-
You know, I've only been here for 10 years, but can somebody tell me why California has the lowest minimum policy in the
Insurance
nation?
lobby.
insurance lobbyists, I'm sure.
We just
Straight.
went up to
Question?
2550.
Oh, you did, hey?
Good. There we go.
Okay. It helps.
It does.
Okay, we got a couple more answers on the board. Anyone can answer at this point because we're not following
Previous
the rules.
collisions.
Yeah,
Prior accidents,
Priors.
yeah.
Yeah.
I grouped that in with prior injuries, so yeah.
Oh, you did? Oh.
Yeah. What about prior attorneys? That's always a red flag
Oh,
for
I
me,
like
right?
that one.
Yeah.
I
Yeah.
love that question. I love that answer too.
What?
Because I feel like we're better than everybody else.
Or if they've had 4 other attorneys and they come
They
to
could
you,
be a
there's
problem.
usually a
I
reason
fired
why.
all of them. My accident happened yesterday.
But there's nothing better than seeing a letter to a prior lawyer where they're offering like $3,000, and then you get them to pay out $1 million. That's so sweet.
I guess, Brandon, one question we would ask is, you had the accident 3 days ago. What treatment have you had? And if it was a month ago and you haven't had treatment, well, that would pose a slight problem.
Yeah. Gaps in treatment.
Gaps in treatment would be an issue.
That's a good question, Ben. I want to ask you because, you get this a lot because you do litigation as well, that you hired an attorney 2 days after the accident.
Yeah.
Well,
Yeah.
I mean, my client doesn't have insurance. What do you
Right.
what do you tell? What do you tell that adjuster or that defense attorney when they put that in writing to you? How dare you?
I generally don't speak to them, so it slides off me. I mean, and at trial, I've never really seen it matter. You just kind of embrace it. They needed help.
Yeah, I guess one of the things that we didn't bring up as an advantage for doing pre-litigation is being able to, I don't want to use the word control because that's not what we're doing, but putting the client in the best course of treatment that they can get. Because, I mean, how many attorneys do you know just send clients, regardless of their injuries, let's go to the chiropractor.
Right.
It's like, that's
Yeah.
not what this person needs, right?
Right.
So, at trial, we get attacked for that, for pulling the strings and doing liens and all that stuff. But the reality is, Brett, in the real world, these people need help. We're not.
Absolutely.
You
Yeah,
need
we take cases with gaps, quote unquote gaps in treatment. That's a term that was defined by the insurance companies. People have lives. Most of them are hardworking individuals that can't take time off work because they have to pay their bills. So, we get that all the time from adjusters. Like, well, they didn't go to the doctor till they hired you, and it's like, Okay, they also didn't know what to do. And they called me to ask, and I told them, and they said, oh, you sound like a helping hand. Why don't you take my case? So you can't blame somebody for trying to get justice and trying to understand what their rights are. And then we just humanize, our clients, the adjusters, and we just kind of get over it that way most times.
I'm very harsh with adjusters.
I am
Well,
too. I am
Which
too.
comes to another point. So I've always adopted an approach, and other people have a different approach, that you can catch more bees with honey
Yeah.
than you can otherwise.
It
So-
I mean, pre-lit and litigation are probably two different things, and it
So-
depends on the size
well,
of the cases.
I
you're
find it in
handling as well.
litigation as well. If I'm litigating a case and the other attorney isn't a jerk, he doesn't have to be my enemy. He can be a respectful adversary, and sometimes you get a lot further in settling the case, or at least, if you designate late, we're all fallible. If you're going to treat the defense attorney like a jerk, don't go be asking favors of anybody. And the same applies with adjusters. I've found if I have a good relationship with an adjuster and I can talk to them, sometimes you get better results by being nice. Now, Ben probably doesn't adopt that
It depends. It always depends.
Yeah, I mean, it's you have a quiver and you have arrows in it, and just being nice all the time probably isn't how you do it, and
Right.
being harsh all the time isn't the way that I always do it.
That's why Ben and I work very well together, because Ben likes to yell at me for getting honey potted, and I like to yell at him for being too mean to people.
Right.
But usually it works out. I mean,
Yeah,
you have to adjust. I mean, there's always always give the other side the benefit of the doubt, because sometimes they are trying to help you and they're just trying to get the information they need, and the other half of the time they're just assholes.
Right.
Yeah.
Right.
I mean, I sound
And if
like-
that's the case, you could deal with Ben.
Yes.
I say that we play nice. I get a temper all the time. In fact, there's a lot of times where I have to get off of a claim because of it. I've called adjusters stupid before. I've asked them if they can read. Sometimes that's warranted. and
That's
it's
a good
needed.
question. But what's the worst insult you've ever given an adjuster, April?
Oh God, I have insulted people, but it only comes after they've insulted me. It's kind of like, probably, are you a doctor? Are you a lawyer? You're neither.
Oh,
so
yeah, I
why
love
are
the
you
letters.
saying that my
Yeah.
client should have gone to 5 less chiropractic treatments or had 1 less injection?
That's what my
Like, who
script
are
says.
you?
That's what my script says.
It does.
That's what their script
Oh yeah.
Oh, there's. It
Just
does?
Reading.
Yeah.
Are
If
you
you're
reading
yeah.
from a
property, then
card?
say this.
What?
Are you reading from a card?
Yeah.
That's what you need to ask
If
them.
Ben says A, then go here. Yeah.
I tell them to put it in a letter.
Yeah.
Oh.
I'll
Always,
say,
yeah,
go
put it in
ahead
writing.
and tell me what kind of treatment you think my client should have received, and I'm
Yep.
going to save this.
Or the
My
best is
staff
like,
actually won't allow me to talk to adjusters anymore. It's
You're your
true.
own worst enemy.
It's,
Nobody protects me from that.
I've had an adjuster admit to me that they don't like my doctors, so that they don't
What?
want to value the claimant what it should. And I say, well, please put that in writing.
Well, you're not the you're not the jury, so I don't
That's-
really care what you think. Yeah.
Exactly.
So I want to talk before we end. We got a couple more topics I want to talk about. Is the business of pre-litigation, right? It's different running a litigation firm opposed to pre-litigation as opposed to litigation firm. And we talked about costs. Barrett, you're probably a different. Oh, you and Deon, you guys have both pretty high volume pre-lit, right? So how do you guys fund your pre-lit machine? Because you have high volume, it can add up. I'm sure those costs are small, but if you have however many cases you have, it's a lot of money to put out there, right?
Yeah.
I mean, we've been going for a long time, and it's just a cost of doing business. So there's no issues with it. I mean, pre-lit costs aren't that high. We do litigate cases, and when we're spending 70, 80 grand on experts, that's when I'm kind of more looking at the bottom line and saying, is this really a good business decision as to what I'm doing? But in the pre-lit, if it's 10 grand, 12 grand, whatever it may be, there's no issue in funding those costs. We'll gladly do it for the client.
For us, the costs aren't necessarily the cost of working the case up. It's more the general overhead of the firm itself. Because the more cases you take on, the more personnel you have to hire, the bigger office you have to have, the more resources you have to have. A lot of the software out there is per user now, so it does get very expensive from a monthly overhead. I mean, we can control that since we're not in litigation, so I know what my monthly overhead is going to be. But we believe in division of labor at our firm, so every particular client's going to have 4 or 5 people working on their case at any given time, doing a very specific task, and that can get pretty expensive. So for us, we're fairly fairly new firm. When I went out on our own, I had 2 jobs. I saved for over a year to build our pot. We started slow, and we got real lucky. We got a couple of great cases, and we reinvest a lot, and that's what's important as you're growing. A pre-lit department or a pre-lit firm is to really believe in what you're building, and we just put everything back into it.
And April?
I mean, staff is everything. I mean, without Ashley and Cynthia and, Nancy and Yesenia and
Is this an Oscar
Yeah,
acceptance
my
speech?
staff's gonna hate me now.
The cast and crew?
Without them, I'd be nowhere.
Yeah.
So I'm very grateful.
April, you're solo, right? Do you have any staff? Any?
I do. I have a couple people. I have 2 people that work for me on contract basis, and then I have now a full-time paralegal. But on the litigation side, it can get very expensive. So early on, when I first opened my practice, I was lucky and a good case fell in my lap, a product liability case, and I actually was very frightened and called Brian Panish through LinkedIn and begged and said, please come work with me. Anyway, I ended up being able to put together a nice lump sum to be able to reinvest in my future litigation cases. And so that enabled me to do that. And then I was still doing some general lit stuff when I first opened. So I'm very careful about my case selection because experts are very expensive. Even if you just have one, it can get pretty high.
You mentioned, Brett, with all the cases you have, case management software. How important is that?
Vital. Without it, I think you're.
I think
going
way
blind.
more for pre-lit than litigation.
Absolutely.
It's absolutely necessary.
For sure. We couldn't live without our case management software, and we're always looking to get better at it and utilizing the resources that those softwares provide you. A lot of people have them, they don't even use it or the right way. So it's it's a perfect tool to manage your cases and to manage the firm itself. I think
You could track negotiations,
Absolutely.
the insurance carrier. I'm sure you could track prior negotiations with that specific carrier
Exactly.
as well.
We go all the way down to adjusters. We have specific
Wow.
notes on adjusters, so we know, when we get a specific adjuster on a case, we know how to handle it from the beginning, whether or not to play nice, whether or not they're going to be, rude from the beginning. So it's vital, in my opinion.
I agree.
April, do you have a case management software? I mean,
I
for
do.
solo, yeah.
I do. I think it's critical if you're solo because you are keeping track of everything and your brain just can't hold it all.
5-6 years ago, I could have. Now I can't keep track of everything in my brain.
Yeah, it gets
It's
tough.
getting
And then
worse.
when you're in litigation too, and you're like,
Too
you
much
cannot miss a
whiskey and-
Timelines,
deadline.
yeah.
Yeah.
You can't remember everything you know.
Yeah.
No.
What?
You can't remember everything you know.
But you could know everything you remember, right?
Hold on.
Solid.
I like
Bring
where
that
you're
down a
going.
little bit.
I like where you're going with it.
All right, so the last thing I want to talk about is, well, before we move on to this, is learning the business of pre-litigation. How did you guys learn? Is it just kind of trial and error? You just did it on your own, figuring out the best way for you? Did you guys work under somebody? Did you have a prior, boss that you used to learn from? How did you guys learn how to work a pre-lit operation?
So I came here from South Africa after practicing there for 16 years, and I knew nothing. There was one attorney who gave me the time of day and gave me a couple of pro forma samples, and you just bullshit until you get it right, and you learn through your own mistakes, and I didn't have the benefit of working under anybody. I guess if I did, that would have been great, but I just made it up as I went along, and I like to think better than most others, but that's just me.
Brett, how did you learn the business of pre-lit?
I got very lucky. I worked with some of the best pre-lit, attorneys out there. When we moved out here from the Midwest, the first job I took was with a pre-lit personal injury firm, a large one that does good volume, but did good work. And I basically learned the business that way. I would say I owe a lot to them and respect them still very much so. They know what they're doing, and that's basically where we learned our operation.
I worked with a few people, but I was never afraid to call anybody who I knew better and ask for things or the process. Or do you have like a template of what do you do next? Who should I reach out to, kind of thing?
Yeah, and I came from Iowa about 10 years ago, and I had a med-mal defense background, and I wanted to switch sides.
You did? You're not a purebred?
No, I'm a hybrid. But in any event, cutting me off.
I like to do
Yeah.
any event.
Mudblood, they call it in the Harry Potter world. Yeah.
TikTok.
So I found this job on Craigslist, and my wife is like, "You need to get a job," because I'm living out in Santa Monica, my hair's growing out, and all that stuff. And so I get this job, and it's at this really high volume place, and they put me in this room, and there's like literally 400 files, and they say go to work, and I'm like, okay. And I did go to work, and got them all done. So that's kind of how I learned.
Trial by fire.
Yep.
Similar to Deon.
Yep.
Fake it till you make it.
That's it.
Still faking it. So.
So the last thing I want to talk about is, you April and Ben, you might be a little different because, well, and Deon too. You do a lot of some litigation, but Ben and April, you do a lot of litigation. Brett, how do you know when to bring in a litigator?
It's a great question.
That's a good question.
It's definitely case by case. I think what's important is knowing when you played all your cards and getting it to somebody quickly. You don't want to wait too long. We don't ever just wait until the 2-year statute. I mean, that just is a disservice.
There's
to
a lot of
your
people
client.
who do.
We don't.
Deon.
So we we work a lot off the policy limits, and that's how we kind of dictate how the cases are going to be worked up from a legal side. And when we get to that point, if they're not going to pay what we believe that they should, then that's when we want to get it out to somebody. And it's important to find somebody who's not going to sit on the case either, right? I mean, if we're dealing a lot with future medicals and trying to play that card, but the client doesn't know to go back to a doctor, and it sits on in a litigation firm for months and months and months and months, and now there's a huge gap in treatment, and then all of a sudden it goes to an expert, it kind of hurts the case from what I hear in the trial and the litigation side. So it's a mutual connection. Finding good litigation firms who can take it on when you need them to, and to know, when to do it, and don't wait too long, I think is the most important part.
So we adopt a slightly different approach. If a case is under 500 grand, we'll litigate it ourselves.
But I mean, you've tried cases. You've tried plenty of cases.
I've
you're
tried, I think,
experienced litigator.
22 cases.
Yeah.
Some bigger, some smaller, and that type of thing. So if they're under 500 grand, we'll generally take them. If it's a 300 grand policy and it's a fusion, we'll take it. And we're expecting to settle it along the way if they don't settle it immediately, pre-lit. If we do a 998 and open the policy, we'll hand it over, because then we realize we could be getting substantially more. So we'll look at it on a case-by-case basis, and we'll look at it and decide. Sometimes we'll take a case all the way up to mediation in an attempt to settle at mediation and hand it over at that point. So we do the original depositions ourselves and do a fair amount of the litigation, and we'll adopt a case-by-case approach. If it's a $5, $6, $7 million case, we'll hand it over at the time of original filing of the complaint.
And April, you do a lot of litigation, so I don't know if you're the right person to ask, but do you ever bring in, a case pre-lit that you say you're not going to get what you want? Do you just take it on your own, you file it and litigate it then?
Yes.
Yeah.
If it's a really big case and I want to bring in a more seasoned attorney, then I'll do that. But I always want to have a big role, because usually I'm the client point of contact.
Yeah.
And if it's referred to me, I'll never lose that. Even if I send out a smaller case to a pre-lit firm, I always remain as a strong point of contact. That client can call, text anytime. Yeah.
And for me, there's, they can just make me mad.
What?
They can just make me mad.
Oh, just the insurance company makes you
Yeah.
mad and you need to bring somebody
Turn
else
it over
in.
to you guys.
Oh, man.
But I think there is an important point to make. It is in everyone's best interest to turn over the right cases.
Absolutely.
I think there's way too many firms that don't realize that. It's better for your client. It's better for you because you end up getting the real value. And, for the younger lawyers out there, you can learn a lot,
That's true.
For all those reasons.
Yeah, that's been like a running theme on our podcast that isn't intentional, that we don't put in there to give ourselves self-advertising. It's very important to know when the case is too big for you.
Absolutely.
And don't be scared of splitting the fee in half, because that half is probably 2 or 3 times worth more than you have gotten on yourself by yourself.
That's
So
Or
true.
more than half.
And
Always.
Brandon, I mean, I've got a family, and you make a decision in life. I'm 50 and I got 3 kids. I don't want to spend 2 weeks in Sacramento trying a case. I'd much rather get half the fee and spend time with my family and do what I do
But that
best.
half of the fee is more than you probably could have gotten on your own. No offense
And that may
to
be,
you,
but that's
yeah.
not the test. The test
Right.
is what's best for the client. And what
That's
do I-
always
and-
that's the end. I mean,
And what
you
do
could-
I want to do? I mean, I don't want to run. I'm starting a case in Santa Ana on Monday for 7 days, and I'd rather slit my wrist. But it's a med-mal case, and I got myself in, and I can't get out. But it's not what I.
But it's the
love
best
to do.
interest of the client to
Yeah.
do it. So.
Correct.
I've even had adjusters say, like, I know you're not going to pass this along because you don't want to lose your fees. And I was just like, how dare you
Yeah.
say something like that?
I
And-
paid her to say that.
Yeah.
So you could bring in.
Exactly. No,
Sometimes I'll tell clients, they'll get upset if I want to bring a co-counsel in that's more experienced, and they're like, well, why would you want to do that? I just
trust
want
you.
you. And then
Yeah.
I sit down, and you have to tell them the truth, that this person is going to be much better. I'm always here for you. And the whole team is here. So sometimes
I've
you have
never
to
had-
talk them into it.
I have that conversation once a week with a client, new
Yeah.
client, and it's once they realize they're getting multiple offices, multiple attorneys for the price of one,
Right.
and they're still your attorney, then that's usually fine. They realize that they have a group of people working for them.
Yeah.
absolutely.
Last thing before we go, last question. One piece of advice if somebody's looking to either out of law school or they're doing defense work now and they want to open up their own firm and they want to do pre-litigation, what would your piece of advice be to that person who wants to start their pre-litigation firm, or even just a pre-litigation segment of a new firm? What would you tell them to do?
There are a couple of things I tell them. Firstly, don't try do it unless you've got sufficient resources to do that.
Absolutely.
If you're going out on a shoestring, you cannot run any pre-lit practice on a shoestring. There's certain amounts of money that you need. So if you don't have that money, rather go work for somebody, build a honeypot and whatever it may be, and do it later. The next thing if you're running a pre-lit practice, I say anybody can do the law. So there are 2 things that are
How
important.
dare you?
If you went to a decent law school.
How dare you?
Yeah. Some of the best trial attorneys out there went to the law schools I never heard of.
It doesn't matter. I mean, of course, it matters how good a lawyer you are. But if you communicate with your client and they know where they are in the process, they will have confidence in you. The worst thing you can do, even if you're not doing anything, is not communicate with your clients. So through my experience, clients who are unhappy are those who have not been communicated with. So whatever you do, communicate with your clients along the way every 2 weeks. Even it's to say, John, I got nothing to tell you other than how you're doing, and I'm working on your case.
Brett?
Yeah, that's some good advice. I think that having a good pot when you first start, if you don't, a lot of people don't, so that's okay. But partner up with people. Trust your fellow attorneys that have the resources to help you out, and learn the system that way. Communication is key, and then put yourself out there. Get clients in the door. Go knock on doors. If you don't have the money to advertise, join networking groups. There are ways to get clients. They trust you if people know who you are and they believe in what you want to do, and then believe in yourself. Be proud of what you want to accomplish. Everyone says how surprised they are that I say that we do pre-lit and that's all I want to do and that's what I love to do, and I'm okay to say that because sometimes it seems like less than, but it's really important part of this business. And if you want to do that, do it and own it, because that'll show in your work product. But we're all here to work together, right?
April?
I think a big thing is gaining experience, because that allows you, when you're a new lawyer coming out of law school, to gain confidence And those things coupled together allow you to communicate really well with a client. Then you get to know your client. You gain that education and experience of that particular client. Then you apply it towards the work, and that will give you, I guess, a foundation to be able to talk to an adjuster or another lawyer. I think the way to gain that experience is to find somebody in your city or state that you can work with that does high volume, that will allow you to work there, and maybe you figure out a split of, if you want more than a salary, and negotiate those things just to gain the experience. Tell them, hey, I need 12 to 24 months of experience. I plan on going out on my own, but I'll do my best work and do it like that.
Those were all great points. I would just say do it. Just go out there and do it. Don't hesitate. I mean, because I think we're all glad we did.
Yeah. There's plenty of people out there who need an attorney that can't find an attorney that, I mean, even just talking to an insurance company for somebody else goes a long way. They can't deal with an adjuster. They don't know what a deductible is. They don't know. I mean, if they find a home, they can be taken care of.
Yeah.
Murat, any advice starting your pre-litigation firm?
I would say try to find a South African mentor for at least.
I found mine today.
Correct. Yeah.
All right, that's the end of the podcast here today. Thanks for listening, and remember, there's no sleep till justice.
They tell me it's cool, but I just don't believe it. Sell out with me, oh yeah, sell out.
Thank you.
Insurance company's gonna give us lots of money, and everything's gonna be all right. Insurance company's gonna give us lots of money, and everything's gonna be all right.